God save the Commonwealth of Massachusetts. Court is open.
Good morning, everybody. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Singh. To my left, Justice Hershfang. We will be hearing 5 cases this morning, I think. I guess we'll see. But I think we'll be hearing 5 cases this morning. The rules are, as they always are here, which is 15 minutes per side with no rebuttal. If a side wishes to divide its time, you have to let us know at the outset what that division is. We do have some divided arguments here, but I need to hear the amounts of time from you all. We've read the briefs and are familiar with the facts of the case, so if it were me, I'd get right into the argument, but it isn't me, it's you, it's your time, and you may, notwithstanding my suggestion, do as you wish. The first case we will hear this morning is number 22-1061, and this is DOSSANTOS versus Beth Israel Deaconess Hospital-MILTON and others. And I believe we will hear first from Attorney Sobchak.
Good morning, Your Honors. May it please the Court. My name is Chris Sobchak. I represent the plaintiff in this case. This is a very simple case. Should all medical records be treated as confidential and be impounded when filed in court? Or should plaintiffs or claimants be victimized twice, and then when they are subject to some kind of negligence, have to be victimized again and have all their private lives exposed for all to see? Medical records and our court systems have changed over time. What used to be files in the old courtrooms were inaccessible to anybody else is now available on an online docket with a click of a button. It's available to all parties, it's available to all public, it's available to all bots.
Can I ask you a couple of factual questions about the medical records in this case? I assume, but tell me if I'm wrong, based on the expert report that they were provided to the expert?
Yes, Your Honor.
Can you confirm that? Were they also provided to the defense at all?
Yes.
So the court and the public, obviously, as you argue, are the only participants in this that did not have access to those medical records?
Correct.
Okay, thank you.
And the court would, had they been impounded, so the issue is, should the public have access to those records? And this actually addresses the defendant's argument, which I was going to address at the end, but I'll do it now. The defendants argued that impounding medical records denies them access and denies them ability to defend the case. That's simply not true. The defendants have those records. They can use them.
How did they have them? Were they produced in discovery, or are you saying they have them because they are the hospital system?
Both. They were produced in discovery, and even if medical records were impounded, they would still be produced to them during the case. Here, they had them before as well, but during the case, once the case is filed, they serve Rule 34 requests, they're produced in discovery.
Were they produced subject to any kind of protective order?
I moved for protective order, it was denied. So there was no protective order in place.
So they were produced to the defendants with no restrictions on their ability to use them or potentially file them?
Correct, which is why I moved for the impoundment to protect the plaintiff from having them exposed to the public. Because an impoundment order doesn't deny the defendants the right to access the records and to use them. All it does is denies them the right to publish them. You can't spread them to the entire world.
In the production of the records, were they redacted so that PII was not visible?
No, they were not redacted because in this case, there was no additional issues that are separately statutorily protected. There is no issues of mental health or any kind of sexual diseases, which the courts generally more typically automatically impound.
I guess I was talking about other information like birth date, social security number, home address, that sort of thing.
Well, social security numbers were not in the medical records, so they'd not be redacted. Birthdays are not redacted automatically, my understanding of the rules. And in medical records, a birthday is one of the things that every single medical record describes because it has to tell you the age of the patients. Those were not redacted. There wasn't anything that would be specifically, separately required to be redacted, like social security number or bank accounts. There was a reference to insurance, but again, that's something that would not be redacted in production discovery. It would potentially be redacted if they're used at trial other purposes. Here they weren't. They got the full records. What they didn't get is the ability to publish them in court. And what I was getting, the second point is medical records used to be where you have 2 or 3 lines description by a doctor written in hand about a appendicitis. Now with electronic medical records, Those same 3 lines turn into 5, 10, 20 times, sometimes 20 pages of electronic records where the patient's entire medical history is automatically copied and pasted from prior encounters. And when you file a simple claim, yes, every plaintiff gives up some privacy by bringing up a specific issues, but they shouldn't also have to give up their entire life. In this case, the plaintiff was a young person who had prior medical issues that she didn't want to be public to the world. And when the court denied the impoundment, we moved to here.
Well, the court actually gave you the opportunity to be more specific, right? Be more specific in your request for impoundment. So not simply impound all the medical records, but specify which ones and to what extent.
Correct, Your Honor.
You didn't do that, right?
Correct, because in this case, there was no other specific records that I would address. I wasn't going to make stuff up and saying there are records that deal with sexual issues or that. They were just regular medical records, which actually under the statute, all should be protected. The court's own form that's been used from SJC down to district court identifies a list of all these particular records that should be impounded and withheld from public.
But even in that form, when they mention medical records, don't they, for example, list particular statutes or regulations?
They do. So, for example, it's in the Record Appendix 114 and 115. They identify mental health records, but they also identify all records. Chapter 70, Medical, Health, and Hospital Records, GL Chapter 111, Section 70 and 70E. So although there are separate subsets, and I believe the list has about 37 different issues that you could check off, those specialized ones are there as well, but also the global, all medical records are one of those things. In this case, which is why our argument is, the court abuses discretion and committed error of law when it refused to impound all records. When it did so, by the time the case came to tribunal, the tribunal did not get the full story, like the court brought up earlier. The parties have the records, both plaintiffs and defense, but the court did not. And the court found that the offer of proof was not sufficient, although even under the standards from Booth, the court could have found that it was sufficient because the letter addressed all providers. They just didn't identify the specific providers. And then my client was faced with an impossible choice.
Can I ask you a question? The tribunal itself, even if this were impounded, would get to see these, right?
Correct.
And is that because they are part of the court?
Correct.
Okay.
My understanding, and I believe it hasn't changed yet, impoundment of records only keeps them from public. The court sees it, the parties sees it, the defense counsel sees them, their clients see them, their experts can see them. The only thing impoundment protects is taking those records, which are now multiple in pages, are a lot more detailed, and puts them on a public website, which are available to everybody else to see. So whether it's somebody that wants to pick on the neighbor and find some dirt on them, or it's some bot, or it's some insurance, or it's a scammer, it just makes them available to everybody else. My client chose not to do that and decided to basically give up her right to justice because she didn't want to become a victim twice.
And can I also ask, I'm not completely familiar with the procedure for convening the tribunal and so on. At what point does the tribunal meet? After all discovery is closed? Before? Like how does it, like what do they have in, what does the tribunal have in front of it?
The tribunal, Your Honor, in medical malpractice cases is one of the first steps in the case. The rule has recently changed where in the past, after a complaint's filed, defendants answer and they have to request a tribunal. Now the rule is where after defendants answer, an offer of proof is automatically filed. In this case it was, with the expert letter, but without the medical records. And then the defense, if they request a tribunal, it's held early in stages. Some initial discovery may be already exchanged based on court scheduling. Technically, under the rule, it's supposed to be done within the first 60 days of the case commencing.
So it's done before full depositions are taken, before all the interrogatories have been answered, before all of that.
Correct, which is why the standard for tribunal is supposed to be extremely lenient, directed standard. Does anywhere in the offer of proof would you substantiate a claim for the plaintiff? And unfortunately, I'll be honest, the courts have done both ways. There is half the cases where a letter that's half as bare as the one that was in this case, the court says it's good enough, half the cases say it's not good enough, and the panels, half the times they overturn it, half the times they overrule it. It's been very, very inconsistent. But in this case...
So your
your statement may sort of answer the question that I had in my mind. It's both parties have represented that in these proceedings, I think your representation was the reason there's no specific case law on point is because impoundment orders are, always allowed. This is we don't have a case where it's actually been denied in this sort of situation. And I think there's representations on the other side is saying this issue exists, there's no case law on the issue because there's never any need for an impoundment order, something to that effect. So I'm trying to figure, of course, I'm trying to figure out what is the practice, and you have very different, and perhaps the practice is different from case to case.
I think the practice has changed. I've only been practicing for 12 years, but when I started straight out of law school, I remember experienced lawyers filing medical records without any concern for impoundment because everything was back in paper only. In the last 10 or so years, I've moved for impoundment in every single case. This is the only instance that was not allowed. Every other time it's been always allowed, and 90% of the times, 80% of the times, it's without opposition from the other side. There is no case directly on point. The Fitzgerald case from the Supreme Court in a footnote does say that the impoundment rule will be amended to include all medical records and mental health records. So that's, my argument is that expands, and there is actually a case law that says all medical records should be impounded. The statutes, both the Massachusetts and the HIPAA, all say that all medical records are confidential, and the form says confidential information should not be in public. But in practice, it hasn't been argued a lot because oftentimes it's a side issue. Parties often don't care about it because if you're bringing a claim about one issue, maybe you don't care that your entire history is exposed. Here, the plaintiff is a young woman that doesn't want to start her entire life by having her past 10 or 20 years of medical what happened to her unrelated to this claim, because this is a single ER instance being open in public for her future boyfriends, employers, or just an AI bot that's going to try to scam her or do something else.
Can I ask you about the other issue regarding just the sufficiency of what was before the tribunal? Without indicating a specific, how a specific provider violated their duty of care, can you really meet your burden?
Our argument is that yes, under the standard for tribunal, it's very low. The expert letter addresses that all the providers violate the standards. The defendant's initial argument was that, well, you don't identify what individual one did. Here, in theory, my client could have, instead of putting her own medical records, wrote an affidavit herself saying, Dr. So-and-so was this, Dr. So-and-so was this, Dr. Nurse so-and-so did this. However, or she could have posted the $6,000 bond. However, that would still mean that she has to proceed with the whole case with an already order in place saying her records will not be impounded, and therefore, in order for her to get justice in the medical malpractice case, she has to victimize herself and expose herself. By not giving that second affidavit and identifying what doctor did what, the case was dismissed, and we're here before you hopefully to fix the wrong and then say that all medical records should be confidential and should be impounded.
But I know you want to talk about the impoundment order, and we hear you on that. But I think Justice Singh was asking a very important question about the adequacy of your expert disclosure. So we agreed at the beginning of the argument that the expert had access to all of the medical records. And it's evident from the report that the expert had that, because otherwise how could he have opined as to what went wrong? Being in the possession of that information, how is it adequate for him to have, how does it meet the tribunal standard for him to have simply said mistakes were made without identifying at least which of the treating professionals was involved in the various stages of the care and whether each of them had a physician-patient or a treater-patient in the case of a nurse or other professional relationship with your client?
Because arguments at this early stage of a case, when you have done no discovery, it's not required. It's not an expert disclosure for trial. It's a tribunal, it's the threshold to say, is there a case here to be litigated? The doctor reviewed the records, the providers, and he grouped them all together because it may turn out that a nurse that did a note after she's deposed, she actually didn't do that note, it was somebody else's fault. So the doctor did not specifically address each individual provider, he addressed all of them. They breached their standard. They are supposed to deal with this in the ER. They didn't. So going back to Justice Rubin's earlier question, because the tribunal is so early, the letter is more bare.
But isn't it always? I mean, I'm looking at the Bradford versus Bay State Medical Center case. That was before a tribunal. And in that case, the SJC held that the allegations in the information before the tribunal were insufficient to show negligence on a doctor-by-doctor basis.
I agree, and that's why I mentioned earlier. I think when it comes to the standards for tribunal, the case law is not settled yet. It varies. In one case, the court will say a letter like this is not sufficient. Another one say they will.
So what's your best case then to counter Bradford? What would you cite back at us?
I would go back to the beginning, Booth. It's that it doesn't require any extrinsic evidence. It's the standard, and it's the fact that it is a de novo decision.
But Booth, unfortunately for you, is a decision out of this court.
Yes.
We're not,
I understand.
We're not bad, but we're not the SJC.
I agree. If there's no further questions, I relinquish my last 20 seconds.
I see none. Thank you very much.
Thank you, Your Honor.
Excellent argument. I gather the appellees will be dividing their time. Is that right?
Yes,
The division
Justices.
that I have is counsel for Thomas Fitzgerald, 9 minutes, counsel for Suzanne Merithu, 2, counsel for,
Anderson.
well, for Anderson, Associate Physicians of Harvard Medical and Purcell, 2, and counsel for Beth Israel Deaconess Hospital-MILTON, 2. Is that right?
Yes, it is, Your Honor.
And it adds up to 15, so that works. We will hear now from you, Attorney Pimentel.
Yes, thank you and good morning. Megan Pimentel on behalf of Dr. Fitzgerald. I want to get right to the heart of the issue here. What we're here for today is, did the Medical Malpractice Tribunal correctly decide that there was insufficient evidence to raise a question of liability appropriate for judicial inquiry? And I've been doing this for 21 years, and just to give you a little bit of background about the way that the tribunal works, it is a 3-member panel made up of a judge, a lawyer, and then a physician in that specialty. And what they do is they evaluate the offer of proof, which contains an expert letter and medical records that support it. The medical records are that substantial evidence that you want to see. So
They're not required to be submitted, though, right? It's not like you can't. Medical records aren't necessarily required at this stage.
In my practice, they are always included.
Are they required?
I believe that they are, because you have to.
Where would I look for that authority?
The substantial evidence that has to be presented, forgive me for one moment. Cap v. Ballantyne says an offer of proof is commonly made by the presentation of documents. Substantial evidence shall mean evidence as a reasonable person might accept as adequate to support that conclusion. Admissible evidence shall include but not be limited to hospital and medical records, nurses' notes, x-rays, and other records kept. And that's all under Chapter 231-60B and supported by Cap v. Ballantyne.
And tell me the citation of what you were reading from.
Sure. 380 Mass 186.
Okay.
In addition to the tribunal statute itself, which is Mass General Laws, Chapter 231, Section 60B.
So it's your position that nothing an expert letter could say could get you past the tribunal?
No. In fact, what I'm going to say to Your Honor is, even if we put aside the issue of the medical records, this expert letter itself is wholly deficient, and I think is really specifically talked about in the Rahilly and Rohde cases. The expert letter itself, in going to Justice Hershfang's point, this expert had the medical records. He had the ability to read them and actually delineate what the role was of each and every provider. This is a complex medical malpractice action in which 6 individual providers are named, and they're all in different specialties. We have a surgeon, we have ED physicians, we have a physician's assistant, and we have nurses.
But no one's been deposed.
It doesn't matter, he has the medical records, so whether or not there's depositions, the medical records...
What makes you say the medical records are accurate?
Excuse me, Your Honor?
What makes you say the medical records are accurate?
They're-
I've seen cases where no one puts down that it was the resident holding the scalpel,
Sure.
right?
I think we generally accept that medical records are admissible under the statute. That aside, that can be worked out later. What the purpose of the tribunal is we have to evaluate what each provider did. You can't have
I just gave you an example where the records don't show who did what. In fact,
I
let
think
me
that's a
give you
rare
another
case.
example. There's 2 surgeons operating on someone. And someone cuts the patient's ureter.
Sure. They're both going to be sued.
I agree with that, but we don't know which one did it.
And you won't, but that's not what the tribunal contemplates when they
So
have
the
the
tribunal
statute.
doesn't need to know what each doctor did. They don't know who cut the ureter. The tribunal can conclude someone with a cut ureter who went in for something that didn't involve cutting the ureter, that person has a claim that's worthy of whatever it is, raises a legitimate
The
question of liability.
Sure. I disagree, Your Honor, and I think the case law is pretty clear, especially the Bradford case, that the expert letter cannot just be generalities.
So
And that's
doctors
what
should be
this-
very careful not to write anything in the medical records that identifies who did the wrongdoing.
That's absolutely not what I'm saying. Medical records are kept contemporaneously in the course of medical care and treatment that is provided. Physicians and other healthcare providers are obligated to accurately record what that medical
Do
care
they?
and treatment was. Yes,
Do
they
they?
do. Our mistake
So
made, I'm not accepting that
I'm
there's
telling you
not.
a hypothetical, 2 doctors,
Sure.
2 surgeons. One, apparently, they're the only people in the room with scalpels, one cuts the ureter of the patient. Anyone in the world would say, that's malpractice. That's not a known risk of the procedure.
It
That-
could be, respectfully.
It's worthy of judicial inquiry whether it's malpractice.
Sure.
Let's put it that way. You're saying that as long as they don't tell which one cut the ureter, neither one goes to trial?
That's not what I'm saying at all, Your Honor. What I'm saying is the case law is clear that in order to evaluate whether it is appropriate for judicial inquiry, the expert letter must say, first, that there was a doctor-patient relationship or a healthcare provider relationship. Secondly, they have to establish what the standard of care is. That has to be established. Nowhere in the plaintiff's expert letter does the expert delineate.
The doctor
not
has
only-
to say, and this would be adequate, I don't know about doctor-patient relationship if he can't tell who did what exactly, but the doctor can say, in a procedure like this, it is not a risk when it's done properly that the ureter will be cut. That is not a known risk of this procedure, and therefore I conclude that to a medical certainty, if it happened, it was malpractice. And that doesn't get us to the court.
Respectfully, that's not what I'm talking about. What I'm talking about is what the case law requires at a tribunal stage, and that's that the expert has to delineate what the standard of care is that applies to each provider. There is a different standard of care that applies to the surgeon than does apply to a nurse in that situation. And the expert actually has to say what that standard of care is. Here, that expert letter is absolutely devoid. So let's get over the fact that we don't even know what anybody did. We'll put that aside for the moment. We don't even know what the standard of care required of each of those individual providers, and they're each entitled to it. They can't all be grouped together. They have specific roles and specific standards of care that apply to them. So you can't just say that everybody.
So even with the medical records,
there.
even with the medical records attached, this has to be kicked out. This doctor letter and the medical records altogether aren't enough in your view.
We'll put the medical records issue aside for the purposes of this argument.
I'm saying if they had been put in,
It still is deficient.
and that's because the doctor has to write, I don't know who made the final call that this young woman had a urinary tract infection, which she couldn't have had because of this and this, and when in fact what she had was appendicitis, and the appendix later burst due to this error. I can't tell from these records which one of these people. Did the doctor reach that conclusion and tell the nurse to send the patient home? Did the nurse reach the conclusion and send the patient home? I can't tell. And that makes it inadequate to go to. Even if they say, and no one should do that, any medical personnel should know the difference between a UTI and an appendix. That's not good enough.
That's not what I'm saying, Your Honor. What I'm saying
You keep
is...
saying it's not what you're saying, and then
What
you
I'm saying
say
is he has to
exactly
say
what I
that-
said in a slightly different way.
No, he has to tell us what the standard of care is. It's not that somebody did something wrong. He's not saying, I don't know who did what. That's not the issue that we have here. The issue that we have here is, one, he does know, but he hasn't said what's required of each of those providers, and the case law is absolutely clear. He has to say what the standard of care is in any medical malpractice action.
So I take it Bradford is your best case for that proposition?
Well, and Rahili and Rhodey as well, the other
Okay.
cases that I cite. The case law is very clear on that point, that the expert letter at this early stage has to say all of those things.
Would you expect, given your practice, sorry to cut you off, but we're so
No, that's
short on
okay,
time,
and I
given
know
your
I'm-
practice
Yeah,
in
you
this
can take
area,
extra.
would you expect that that the experts, at least the ones who do this work with some frequency, have sort of a cut and paste standard of care for various situations? I mean, that it's something that would be available, you know, a treating physician, an ER physician, an ER nurse, you know, whatever the categories are?
So I will tell you that what we typically see in one of the biggest plaintiffs' medical malpractice firms is Rubin and Meyer. Their letters typically state the standard of care that is expected of the average qualified nurse at the time and under the circumstances is thus. It says 1, 2, 3. And this is how that nurse violated the standard of care, how their care and treatment breached it. And then lastly, this is how that breach caused the harm. And that's, it is like a form almost
Yeah.
that they use, excuse me.
And so putting aside for a moment the latter parts of that, the standard of care piece, and don't get me wrong, I'm not looking to change the law here, but the tribunal, consisting as it does of at least, you know, 2 out of 3 members who know this world, presumably the 3 people in the tribunal, or 2 of them, have that information probably well at hand. By that information, I just mean the standard of care, not the other pieces.
Well, the medical, so this is why there's a medical person in that particular specialty, because they are understanding, one, what is required of that person in that specialty, and then the judge and then the lawyer come in to say, that does the language meet it? Do those 2 things mesh? And that's how they come to that decision. Thank you.
Well, no, we're going to actually keep going.
I'm sorry.
No, that's
My
fine. I've
apologies.
dominated the argument. I want to let my
I don't want
colleagues
to be dominating.
ask a couple questions.
So
But I
don't
appreciate
know
the
if this-
time.
I don't know if this might be addressed by one of your brothers here, but on the issue of impoundment,
Yes.
you were the only party to actually object to that motion, correct?
I did, and so that had a long history. So the plaintiff filed the motion for impoundment after the offer of proof had been filed. That was my opposition. Separately, he had done a motion for protective order. Those were denied. He was given an opportunity to be more specific. He did not. Then there was a motion for reconsideration, denied, and then it went up to the appeals court.
It appears that all defendants were not on the same page with respect to the impoundment. It appears that some defendants were fine with the impoundment, and it was only your, is that correct, that it was only your?
I can't speak to whether or not they were fine with it. I took the lead on it. I will tell you in practice, and again, I've been doing this for a long time, we do not typically impound records. That is not the way that.
Why do you object to it?
Because it's cumbersome. There's no reason to do it in
It's
practice.
cumbersome to impound a record? We have impounded cases all day long.
What I'm saying is, in the typical practice, one, we don't do it. He didn't meet a showing in order for us to impound
I'm just
these
surprised a
records.
doctor wants to not impound medical records.
Excuse me?
You represent a doctor?
I do.
I was surprised that a doctor would object to the impoundment of medical records, which are obviously private.
They are all the time are presented in court all the time. That is how this happens.
Okay,
day
because
in and
people
day
don't
out.
ask to have them impounded, but I'm trying to figure out.
It's generally if there's something specific, whether it be an STD, the HIV statute.
So tell me
mental health records,
what
those
in a
are-
medical record is not private?
I don't believe that there is the threshold.
Every diagnosis I've ever gotten for myself, I consider private.
I don't think that the
Sore
law
throat.
supports- I think that they, under the law, they are allowed to be used in judicial proceedings. There
Yes,
are exceptions.
impounded items are
But there's
used.
not a carve-out that says they must be impounded.
I'm sorry, do you agree, because your brief seems to say otherwise, do you agree that even if they're impounded, the parties see them, the court sees them, and the tribunal sees them? Do you agree with that?
If they are impounded, I believe that is the case.
Okay,
It
so
was-
what is your objection?
Because there is no threshold showing that says that all medical records must be impounded. That is not what.
Well, that's the question before us.
Respectfully, I think the question is whether or not the tribunal correctly decided the decision, not whether or not they correctly decided whether they should be impounded.
Right. I think what you're saying in legal terms, I'd like to act a little legal from time to time, is that it was in the discretion of the Superior Court judge whether or not to impound them, and he chose not to.
Yes, and that issue was appealed and denied.
More? Okay, thank you very much for an excellent argument.
I appreciate the time. Thank you.
Sure, we appreciate your time. We will hear next from Attorney Bruce.
Good morning. I am John Bruce on behalf of the defendant appellee, Physician Assistant Suzanne Merrithew. May it please the court. May I begin, Justice Rubin, by responding to your analogy about two surgeons and the severed ureter? What is required in an offer of proof in that circumstance is a letter from an expert saying, can't tell from the records how this happened, but the ureter would not have been severed but for in the absence of negligence, or in other words, res ipsa loquitur. And I'm sorry I can't think
We
of
don't
the
have
case.
res ipsa.
Well, but what is required is an expert who says this complication, this injury to the ureter would not have happened in the absence of negligence, which is an entirely different scenario than this case. Another question that you asked was, even if the records had been included in the offer of proof, would we still say the offer of proof is insufficient? And we argue, yes. And Physician Assistant Merrithew is a perfect example of why. When you look at the offer of proof in a letter of the expert opinion, do you know what PA Merrithew's role was? Do you know which of the two emergency room visits she was involved in? Because there's three allegations. Two of them involved the first emergency room visit, where she wasn't even present. You wouldn't know that from reading the offer of proof. And on a directed verdict standard, it couldn't possibly prevail with respect to
Do you
PA
agree that even if an offer of proof is wrong, it may be sufficient?
Yes.
Okay, here's what it says in the offer of proof, in the letter. Based on my review of the aforementioned records, it appears there have been several instances where the standard of care was not met, including a misdiagnosis, delayed diagnosis, and delayed treatment of appendicitis, leading to likely avoidable episodes of abdominal sepsis, need for laparotomy, intensive care unit stay, prolonged antibiotic therapy, intra-abdominal abscess necessitating additional surgery, reactive pleural effusion necessitating thoracentesis, a lengthy hospital stay and recovery, and significant pain and suffering. And it's because of a breach of the standard of care, says this doctor.
It does say that.
Why is that not worthy of judicial inquiry? Not that they win. I don't have any idea, of course, what happened.
Right.
I'm just surprised that that's found inadequate to move forward past the tribunal.
The offer of proof must be sufficient with respect to each of the defendants, not the defendants as a group, as a collective. And you can't find against P.A. Merrithew based upon this offer of proof. It doesn't say what she did when she was
Okay,
involved.
but if we go to my two surgeons and the cut ureter, you agree that that would be adequate to bring both of them before?
I don't.
So if they don't write down in the records which one cut the ureter,
Oh, I'm
and they
sorry.
don't,
I misunderstood. Yes, a letter from an expert saying, I don't know which of the two surgeons cut the ureter, but one of them had to, and that's negligence. That would be a sufficient offer of proof. Because as I was arguing, If the complication would not have happened but for someone's negligence, that is sufficient. But we're not
Can you
talking about
move
that in this
before the
case.
tribunal to have this not go forward as to your client on the basis that your client enters an affidavit saying, I wasn't even in the room during the misdiagnosis?
Well, we can discuss whether it's appropriate to shift the burden to the defendants at the medical malpractice tribunal stage, but that's not what the statute requires. The statute places the burden squarely upon the plaintiff to prove that there is, in fact, a legitimate inquiry appropriate for judicial inquiry. So it is not Physician Assistant Merithew's obligation or burden to prove she wasn't involved. Now, this doesn't come up because in the 31 years I've been practicing, and I'll share my observations with the tribunal over the years if you want, I've never seen an offer of proof without medical records, other than filed by a pro se plaintiff. It's the first time I've seen a request for impoundment, and the plaintiff then declined to attach the medical records.
But wait a minute, let me make sure I understand, because my understanding of what happened here was that the tribunal did have the records. Is that incorrect?
I think that's incorrect.
Okay.
I'm sorry, did you say incorrect?
Incorrect.
The parties had it.
Yes. If you look at the docket that's in the record appendix, there were 4 orders for medical records that were approved by the court, one of which was this hospital record. So the parties had the records. So,
And nothing kept you, I understand it's a burden question, but nothing kept you from introducing them to the tribunal. There's no impoundment order, right?
right. But again, that's an impermissible shifting of the burden of proof to the defendants. I know I'm over my time.
That's all right.
One more question that you asked. Can an offer of proof be sufficient without medical records? I suppose conceptually it could be, but it would require a whole lot more information in the expert letter than we have in this case. It essentially would have to say what the roles were, each of the defendants who were allegedly negligent and whose negligence allegedly caused the harm, and would have to provide a whole lot more specifics as to what Physician Assistant Merithew did or didn't do. And none of that is in this expert letter. And that's the reason why, with respect to Physician Assistant Merithew and each of the other defendants, we believe the offer of proof is insufficient, irregardless of whether the records were provided or not.
Okay. Are there more questions? You are out of time, but thank you very much. And we will hear next from Attorney Puleo.
Good morning. Yes, John Puleo. Good morning, members of the panel. On behalf of affiliated physicians of Harvard Medical Faculty Physicians and Dr. Purcell and Dr. Anderson. I acknowledge that the impoundment issue is an interesting one, but I think it's not necessary to decide this case because, as has been observed by my brothers and sisters and questions from the panel, even if the medical records had been included, there's no question that under the controlling case law, the expert letter is insufficient. The standard of care may be templated in the Rubin and Meyer case, but it's often a question of fact, to use Justice Rubin's example of if a ureter is cut. Well, there are some procedures.
You used a different example. That's so yucky.
Malpractice can be yucky.
There are some procedures where inadvertent and unintentional cutting of a ureter is not negligence. It's a known risk and complication of a procedure. But there are others where the surgeon should be nowhere near the ureter, and if it's cut, it's not res ipsa. But the expert needs to say, this is a case where it's not a known complication, so the standard of care would require to avoid the ureter. And
well, this doctor says the standard of care is don't misdiagnose appendicitis as a UTI.
And respectfully, it's not this is medicine we're talking about, right? Not these hypotheticals that a lawyer brings, with all due respect to my brother. In terms of and I will answer your question, a patient can have appendicitis as well as a UTI, right? And so the question of when are the clinical facts and circumstances.
The doctor specifies that there's 1 or 2 tests that were negative that I don't know if they actually completely exclude UTI, but my understanding is that the doctor says if someone saw this and this, they shouldn't have thought it was a UTI. The doctor may be wrong, of course.
Our position under the controlling law is that the standard of care of when a physician is required to rule out a UTI and conclude that it's appendicitis is not black and white.
But that's what a trial is for. See, there's been a lot of talk about how inadequate this is. It's certainly inadequate to support a judgment, but there hasn't been full discovery yet or a trial, right?
No question.
I mean, there are summary judgment motions later if nothing, if the detail demonstrates something else after the uncontested testimony of some people, right?
No question. But respectfully, the reason that we have a tribunal is because of the legislature's decision that there were inappropriate cases being brought without sufficient basis. And so this was one mechanism 50 years ago now already to try to screen out, as you have observed, unfortunate medical outcome versus a legitimate case for judicial inquiry. And the law that has developed from this and the Supreme Judicial Court makes clear that it's not enough to say there's multiple instances of negligence by multiple providers. It's simply not enough, because not all the providers are named. 8 of them are that are represented here, but the expert did not say Dr. Purcell was obligated to, the standard care applied to him, he should have done this test, he didn't, that's why he allegedly misdiagnosed. Dr. Anderson co-signed the note, and his involvement is this, he was required in that circumstance to do this and that, here's where he failed. And there's no suggestion, to your other point, with all due respect, are people that create medical records, are they human and their inaccuracies or mistakes? Of course. There's no suggestion here that there's anything inaccurate in the medical records.
No, I'm not saying, I was talking about in the hypothetical.
So again, I think the impoundment is an interesting issue. You're right, I did not object to the impoundment. As a practical matter, it's because I was too busy at the time, but I am indifferent to whether impoundment records get impounded, as long as I can have access to them and defend the case. But the tribunal did not have the medical records, but even if they did, it's clear in my position respectfully that the expert letter is insufficient under the controlling case law.
Okay, I want to know. All right, seeing no
Thank you
further
very much.
questions, thank you, and I believe that
We've
brings
got one
us
more.
to Attorney Braun.
Members of the panel, good morning. May it please the court, my name is Dan Braun. I represent Lynn McKinney, Vanessa Martin, as well as B.I. Milton. Much of what I would say here this morning has already been covered very ably by my brother and sister counsels. It is my position on behalf of my clients as well that the offer proof is insufficient, and that's really the issue at play here. As Attorney Paleo pointed out, the impoundment issue is an interesting one, but it is not dispositive here in this case. The matter at issue is whether or not the expert letter as presently constituted is sufficient to meet the burden. And in my estimation, this is simply not good enough. These are professionals. The standard of care is beyond the ken or understanding of the average juror or average person, and therefore you need, as a professional, you need a professional standard of care opinion in order to even lay out a claim. That doesn't exist here. So with that in mind, adopting and incorporating by reference the arguments of my fellow counsels as well as the arguments constituted in the brief, unless there are any additional questions for me, Your Honors, I will rest.
Very good. I see no further questions. Thank you all very much. Thanks for taking the extra time to answer our questions. And the case is submitted. The next matter before us is number 22-1045, Stearns versus Montero. We will, when everyone's ready, we will hear first from Attorney Sinrich.
May it please the court, Scott Sinrich from Marianne Stearns. My client is here today because the judgment entered by the clerk does not reflect the findings of the trial judge in this matter.
So I hate to stop you right at the beginning, but I'm going to anyway. You referred to the judgment in your briefing the same way you just referred to it, as the judgment entered by the clerk. And I understand as a practical matter that it's the clerk who actually puts the judgment in the system. Given the procedural posture here, where there was a motion for reconsideration that I think was heard, there was a hearing on that motion.
Correct.
We don't have that transcript. And then denied by the judge who had presided over the matter. How did the judgment not become the judge's judgment, at least through that process?
Well, the denial dealt with a motion to amend the judgment. I think the judge made an error, and it's interesting because we're not here to question the judge's findings. We're here to question the judge's denial of the motion to amend, which I would argue would be a de novo review.
But even if I were to agree with you that the judge made an error, and I'm not saying I do or I don't, I'm still troubled by the disconnect between the rule you have cited, which is a rule that has to do with clerical error,
Right.
and the procedural history of this case in which the judge, assume for the moment, I don't know how this happened, assume for the moment the clerk wrote the judgment, entered it, you filed the motion saying that this is messed up, we need to have it redone. The judge then reconsidered it and wrote in the margin something like denied the judgment shall stand. How is that still a clerical error?
It's not at that point. I would agree with you.
Okay, so that brings us to 60B.
Right.
Did you argue 60B at all in the Superior Court?
I did not argue 60B. It was, the motion was drafted based on the clerical error. That's what we believed going in because the findings were so clear on their face that during the oral argument, the judge actually didn't indicate anything. There was no discussion that would indicate the judge felt that somehow, despite the findings, the judgment was correct. So and perhaps it was my error, but my error was that with the findings so clear that it had to be a clerical error, and that obviously turned out not to be the case. I would have loved if the judge had given us an explanation of how he could have found constructive trust on the 2009 deed, that it was held for Ms. Stearns' convenience because she couldn't manage her property, and yet there'd be no reference to constructive trust in the judgment.
Clerical error, so far as I can tell, is defined in the rule to include omissions. So it seems perfectly fine to me that you would file under that rule something saying you've omitted the section of the judgment. Now, I agree that if the judge then says, like, no, I deliberately did it, then the judge is saying it's not an omission.
Right.
But I don't see why you have to bring it, then bring a substantive motion or something under 60B. It seems like at the time you made it, and given what your claim was, it probably, I'm not sure about this, but it probably was brought the right way.
Well, I hope you all agree to that effect.
We do.
There clearly was no omission. There's no way to reinstate the 2009 deed in which Marianne and her nephew owned the property as joint tenants, and then find, no, Matthew was on the deed simply because his aunt could not manage the property and he was holding it in constructive trust. This arose...
The judge allowed the amendment of the complaint, right?
Yes.
So there's a complaint that makes a claim for a constructive trust and asks that one be, I think the words you use are entered or given, but I guess I'll say what the cases say, imposed, a constructive trust imposed. It seems like that's what you were asking for, and there's nothing in the judgment one way or another about that, right?
It doesn't mention constructive trust. And so we would focus, in fact, The reporter's notes to Rule 60A cite a New York and Georgia case, and basically both of those cases say that the judgment has to reflect what actually took place at trial, and it doesn't. It doesn't mention the constructive trust. And while I know that you're loath to consider what might happen down the road, it's been made very clear to us that the next step is a petition to partition and sell the house if Matthew is in fact a joint owner.
Has that happened yet?
It has not.
And I trust that if you were to prevail and get a different judgment, again, who knows what will happen. I mean, collectively, somebody here will know. That was something that would be filed in the Registry of Deeds so that that judgment was available to anyone who was looking at the deed of the property.
We could absolutely file a certified judgment in the Registry of Deeds. It also would be really an absolute defense to a petition to partition if he is not held to be a joint owner. So yes, it will affect the next step in the proceedings. I think that the real issue is whether this court has a firm conviction that there was an error made between the findings and the judgment. And it's impossible to read the judge's findings from number 13 to 15 not to understand that at least at trial, maybe 6 months later, when there were 24 or more cases in between, the judge heard the evidence over a 2-day trial, heard Matthew admit that he was given the property to manage for his aunt, and I don't want to argue the facts because we're not challenging the findings. I know there's a dispute as to whether he paid money or didn't pay money. In any event, the judge found that he was not a bona fide owner. He was a grantee on behalf of his aunt. And so if the court is to take any action, it must take action so that the judge's findings of constructive trust apply going forward. And without amending the judgment, it's very questionable whether those findings would have any lasting effect.
So this is a little bit of a pop quiz from the bench, and if you don't want one, that's fine. But I was sort of thinking through another way of characterizing what you describe as a flaw in the judgment, and it struck me that Rule 54B of the Rules of Civil Procedure, which you do not cite in your briefing, might be relevant to this. And under 54B, obviously it allows for the entry of a partial judgment if the judge makes express findings as to why that is required. It goes on to say, in the absence of such determination and direction, any order or other form of decision which adjudicates fewer than all the claims or the rights and liabilities of fewer than all the parties shall not terminate the action. It's not fewer than all the parties, so that part isn't directly on point, but might a way of looking at your argument be to say that this judgment actually doesn't reach all of the claims and therefore was not a final adjudication?
It might, and that could have been a way to go forward. I think Justice Rubin talked about omission, and so if the constructive trust was omitted from the judgment, then it appears that it's only a partial judgment on the issues that were allowed by the trial judge when we were able to amend the complaint. If there's nothing further, I would rest on the papers. Thank you.
I see nothing. Thank you very much. Interesting case. Excellent argument. We will hear next from Attorney Raphael.
Good morning, Your Honors. Bruce Rafel. I represent the appellee, Matthew Montero. I'd like to just suggest that the case that's before your honors is a very narrow issue. And the issue is, and quite frankly, the appellee's position is that Judge Glenny's denial of Stearns' motion to amend the judgment wasn't in error and should stand. And I think Justice Hershfang had indicated at the outset, and I think it's a great point, that Judge Glenny actually heard a post-judgment motion on this very issue and denied the motion after hearing these same arguments that are being presented to your honors. And I would suggest that the reasons for our position, as cited in my brief, are as follows. First, I would suggest to your honors that the judgment was not based on a clerical error pursuant to Mass Rules of Civil Procedure Rule 60A. As the court has already indicated briefly, 60A is limited to clerical errors, clerical mistakes, and it indicates very specifically transcriptions, copying, miscalculations.
Omissions.
Omissions.
So I take it your brother's position is the judge omitted to address our constructive trust claim in the judgment.
But the problem with that argument, Your Honor, respectfully, is that 60A addresses clerical error omissions, not substantive omissions, not intentional omissions.
Okay, why would the judge have intentionally omitted to address one of the claims before him?
I don't believe that he did, Your Honor, respectfully.
You said it was an intentional omission.
No, I'm saying that that the issue at hand is an intentional one. The judgment, the findings are intentional. I don't believe that he intentionally or unintentionally omitted anything.
Okay, so let's leave aside for a minute what part of 60, if any, is applicable here. Why is it correct, and how is it correct for the judge not to address one of the claims in the complaint, in the judgment? Why doesn't the judge have to say either there is or isn't a constructive trust?
Sure. So first and foremost, Judge, and I cited it in my brief, the appellant in their verified complaint, and then subsequently in their amended complaint that was amended, quite frankly, as late as several years later, and 4.5 months prior to the trial date, in their own complaint, they requested specifically the relief that Judge Glenny made as a judgment.
And also they requested that he enter a constructive trust.
Correct, but not a constructive trust to make the 2008 deed that was there before the litigation even started as joint tenants that was done for consideration.
I have to look again. That didn't strike me when I read the amended complaint. I'll look again and see.
So if you look at the...
So you think they didn't ask to have a constructive trust entered?
No, I want to be very clear. They asked in the second complaint...
Yeah, but the second complaint's the operative one, right?
No, of course. But I wanted to just say that they asked for a constructive trust to be entered, but not, they didn't say that that meant that on the 2008, they were asking for monetary type damages. I can, let me...
Well, I think they asked for both, but I'll obviously we'll have to look if they specified that not that they generically wanted a constructive trust imposed going forward.
Your Honor, it's RA 24 in page 25. Wherefore, Stearns respectfully requests that a constructive trust be entered in her favor in an amount to be determined by the court.
Okay, but now there's a constructive trust. I'm looking at the questions. The questions include a constructive trust section, you know, the special verdict form. And the judge answers yes to every one of the questions under it. Was there a relationship of trust and confidence? Yes. Was the transfer of the deed only for convenience purposes? Yes. Did the 2008 deed, under that deed, or at the time it was issued, did your client hold the property in constructive trust? Yes. Now then, they go, I guess the judge wouldn't have had to do the next section if he hadn't found that, because the next section is what's the amount of unjust enrichment, and he does conclude 0.
Correct.
But that's not the same as concluding there's no constructive trust.
Right. But what I'm suggesting, Judge, you have to look at all the findings, not just the findings that, that the appellant wants you to look at. Finding number 12, do you find that the December 4, 2015 deed should be rescinded and that the September 12, 2008 deed should be reinstated?
Of course.
Yes. And that's the exact judgment.
Okay, but the next question under constructive trust 15 is, do you find that the September 12, 2008 deed created a constructive trust, or at least that as of the date of that deed, it was held in constructive trust? Now, maybe something has happened since then to undo that constructive trust?
No, Judge. So the way I read question 14, was the September 12, 2000 deed transferred for convenience purposes so that the defendant could assist the plaintiff with managing the 252. This is how the judge, the constructive trust is how the judge was made the decision to rescind the 2015 deed that they found, that the judge found was done by undue influence.
So you're saying that the 2008 deed, the transfer was to be held by your client in a constructive trust for your brother's client?
No, not at all. That's what I'm absolutely not saying.
That's what it says, number 15, I think. I don't understand.
No, number 2000, so number 14 says, was the September 12, 2008 deed transferred? So it was transferred in 2015. So
no, that's a fraudulent transfer. We just heard under damages. Do you find it should be rescinded because it was done due to undue influence, fraud, incapacity, or mistake? This is number 11. So it can't be that the judge is saying, oh, was it done for convenience purposes? The judge has already found it was done for fraudulent or undue influence.
no, the judge respectfully on question 5 absolutely said no fraud.
What does number 11 say?
Okay, but they say undue influence, so.
Undue influence, yes.
so
I would
undue
agree with you,
influence.
Judge. Undue influence, but not fraud.
All right, so it wasn't done for the convenience of the, if it were done for the convenience of the plaintiff, you'd leave it in place. But it was done through undue influence, so it's rescinded.
You would have left, right, correct. You would have left the 2015 deed in place. They're asking, Your Honors, or they asked first the first judge to undo the 2008 deed for the first time post-judgment.
Not undo it.
To return to it.
And declare what it means.
Well, what it means, I mean, it was in 2008, for consideration, the deed was transferred to my client and the plaintiff as joint tenants.
In a constructive trust for the benefit of the plaintiff, says question 15.
But that was never the way it was held.
The judge has checked the yes box. I don't understand.
I mean, a constructive trust is an ex post facto activity, right? So when you say that's never the way it was held, of course you're right, because that's the constructive part. So my understanding of the question that was asked to Justice Glennie is, in number 15, do you find that as of the date of the first transfer that involved your client, the nephew, the defendant, your client, held the Elm Street property in a constructive trust? So looking back from what you know now, Justice Glennie, at the purpose of that transfer in September of 2008, even though the deed just says to the two of them, and it doesn't say anything about a trust, having heard all the facts in the case, do you believe that the intent and purpose of the parties, and also the sister and the other people who used to own the home, was that your client, the nephew's ownership, was not, as it appears to be on the face of the deed, but was actually as a constructive trustee for his disabled aunt?
Right,
That's what I understand 15 to mean. Am I wrong? I've been
See,
wrong.
I would respectfully suggest yes, and I think Judge Glenny's decision reflects that. I think what Judge Glenny did was find a constructive trust in his findings so that he could then rescind the 2015 deed
No, he
and
rescinded
go back
that
to the
because of
2018.
he rescinded that because of undue influence. Then he was asked some questions about whether a constructive trust should be imposed or was created by the 2018. At least that's how I read it. I mean, I understand you're saying that's not what it says.
In Judge Rubin, the undue influence part is separate from the undue influence part, which is separate from the damages that was requested. And so they're all separate theories to get us to where Judge Glenny wanted to go.
I don't understand why it being placed in constructive trust in 2008
So that's what I'm suggesting.
makes you rescind the later deed. But even if it does, they did ask, and I'm looking at the complaint, they asked, grant plaintiff a constructive trust in an amount to be determined by the court. And this is in a request for relief that also says they ask for something slightly different. They say that the December 2015 deed should be reformed so it's exactly like the 2008 one. Instead, the judge has rescinded the 2015 to the same effect. And then they say, enter constructive trust. Okay, I don't.
If I may, Judge,
Shouldn't the judgment then have said, let's say you're right, shouldn't the judgment still have said, I decline to impose a constructive trust? They asked for that, but I'm not giving them that because I find that they asked for the 2015 deed only, and I have rescinded it.
and Judge Glenny may have, and I don't want to get into Judge Glenny's head, but that may have been exactly the reason why those are the damages that he awarded. And quite frankly, those were under the findings. The only question for damages was checked, which matches the judgment. And again, without getting in Judge Glenny's head, I suspect that the reason for the findings of a constructive trust was that he could undo the 2015 deed, not the 2008 deed, which my client paid consideration for. And quite frankly, this wasn't even an issue at trial, and it wasn't an issue in the complaint.
Looking through the complaint and the findings and the judgment, the complaint contains 6 counts. The special questions and the findings in response to the question address each of those counts. The judgment addresses only 2 of the requests, or in any event, because I think it's a little mushy, doesn't address all of them. Do you agree with that?
I believe I do, Judge, yes.
How is that an adequate judgment to resolve the plaintiff's claims when it does not address each count of the complaint?
Well, maybe I misunderstood your question, then I apologize. I do believe it addresses all the issues because at the end of the day, the complaint requests money damages and requests an equitable remedy to rescind the 2015 deed and bring back the 2008 deed. And he did both. In his findings, he found 0 monetary damages, and in his judgment, he did just that, the same thing that we asked for in the findings.
But you are now incorporating the findings into the judgment to answer my question. And my question is, how does the judgment address all of the issues? putting aside the findings, because I take it you are not here arguing that we should construe the findings as part of the judgment, because then there would have to be some sort of constructive trust. I understand you have a theory of what that would be, but the words constructive trust do not appear in the judgment.
Correct.
And the judgment standing alone does not say, as to count 6, requesting constructive trust, I determine X.
Right. And respectfully, I don't think Judge Glenny's judgment has to specifically state, well, this is how I got here by constructive trust or by undue influence or by fraud or by any of the other theories that were proposed. And quite frankly, I think that, you know, and I'm running out of time, so I want to make sure that I...
But you can answer Judge Hershfang's question.
I want to make sure that I address what, you know, and I don't want this to be lost on the panel, and I know it's not. You know, the standard on appeal that we have here is abuse of discretion. That's a very high burden. We can't take this case de novo, and in the case law in 60A is very clear that factual and legal decisions deliberately made or corrections of error of substantive judgment, even if erroneous, even if the judge's findings, even if you were to find that the judge, hey, the judge is just plain wrong. He should have addressed all these other issues in making his judgment. You know, unless his judgment is clearly erroneous, the abuse of discretion or his discretion shouldn't be touched.
I think we understand your point. Are there further questions? Thank you very much for your argument. Very good argument. These are both very good arguments in another quite interesting case. It is submitted.
Thank you very much, Your Honors. Thank you for listening.
The next matter we will hear is number 22594. This is Harvey versus Assed. We will hear first from Attorney Kramer.
Thank you. Good morning, Your Honors. If it please the Court, my name is Attorney Scott Kramer, and I represent LUZ and Michael Harvey. As you've said, you've read the briefs, you've read the facts, and you know then that this entire case focuses on one case. There's really one case that governs this case, which is Creed versus Audet. This case tracks that case so overwhelmingly an accident with somebody who gave the police the wrong address, an address that isn't their last and usual address, that the attorneys relied on that address, and as a result, were not able to properly comply with statute chapter 90, section 3C. Now, it's a little different here because we're not talking about Connecticut. We're talking about a person in Brazil. We're talking about what Creed versus Audet doesn't talk about is the duty, the obligations under other areas of law, criminal law, no less, to give an accurate address. Chapter 90, section 24. If you hit somebody, you knowingly collide, and you don't leave your residential address, it's a crime. You can go to jail for 2 years. Chapter 90, section 26, you're supposed to file a police report within 5 days. Yet, Mr. Assed didn't do any of those. Now, there's an argument that my brother made that he was somehow coaxed or led to not making the right representation because he said, I just want a local address. First of all, I'm not sure that the court should accept that representation in a
Well, I
self-serving.
mean, we don't do that, any of that stuff, right? We're not here finding facts. That's just really never our job. I mean, sometimes it's our job in a fuzzy sort of sideways way, but it's really not what we do here. And so I hear you that you think that there is some fault here on the part of Mr. Assed, that he had duties of candor, responsibility, criminal obligations to provide information, but we're not going to assess those duties. It's not before us. So what is before us is that there was an accident in which Mr. Assed essentially conceded liability, according to the police report, that he provided an address to the police that was in Medford. Why he provided that is not something that we are going to determine here. So it's not helpful to advance the ball with us to talk about, what his criminal responsibility might have been or why he didn't provide it. I think the question that I have for you about the address is it's undisputed that he provided a Medford address to the police. That's the only address that's on the police report.
That's correct.
What makes that his usual place of abode?
Your Honor, I believe the police report itself lists that as a residential.
I'm sorry, why are we talking about usual place of abode?
I don't know, because I asked him about it.
No,
That's
I
why-
understand, but then he answered you.
Well,
Who
Your
cares what his usual place of abode is? You served him at the registry.
Well, before we served him at the registry, Your Honor, we served him at his last and usual place of abode.
Okay, well, we don't know anything about that, I suppose. I don't know whose burden it is to show what's last and usual, actually. But what difference does it make? You did serve him at the registry subsequently.
Correct, Your Honor.
That's adequate service, as I read the registry service portion. I thought the only question was whether adequate notice had been provided under 3C.
Well, respectfully, Your Honor, I'll finish that, but I do want to circle back to the other issue.
Yeah.
Under 3C, there's essentially 3 steps, 3 issues. Step 1, you have to serve the registry. That was done promptly in May of 2000.
That is effective service of process.
I agree.
Okay, so if the question is service of process, and I don't know if it is, because presumably you have to comply with 3C, and I guess, was this dismissed for failure to comply with 3C?
Well, correct, Your Honor, because
Okay.
the second part of 3C requires actual notice on the person that you don't have a correct address for. In other words, and 3C lays out a number of options.
No, it doesn't. Where does 3C require actual notice? You can do either paragraph 1 or paragraph 2. Do you have it in front of you, the statute?
I do, Your Honor.
Doesn't it say in the manner provided in paragraph 1 or that provided in paragraph 2 hereof? That's how you give notice. And paragraph 1 says if he's known to be the holder of an operator's license from another country. You didn't know that when you filed the complaint, right?
Correct.
Okay, so then down below, if he has no vehicle registration or license known to the plaintiff, such notice and copy shall be sent in the same manner, which is to say return receipt requested, registered mail, to the last address of the defendant known to the plaintiff. Didn't you do that?
That was done, Your Honor. It was done several ways.
And, okay, but if you did that, it then says affidavit of compliance herewith and the defendant's return receipt or other proof of actual notice. The return receipt wasn't sent back. We'll have to figure out what to do about that. The legislature must have known return receipts aren't always sent back. Up above, they refer to, and I know this cuts both ways in a way. Up above, they say, under, if you know, the defense return receipt, if received by the plaintiff, shall be filed. I mean, I don't understand. Maybe I'm just missing the whole thing. And really, these are questions for your brother, I think. The whole point of this statute is to allow service to be valid on a person who's out of the country but came here, drove a car, and caused an accident. why actual notice would be required before you can go forward. Usually people you won't find the person, right? I mean, in this case, they happened to be a rental car, and eventually through discovery, you were able to track down where the person is. But imagine he hadn't rented a car, he's driving his kid's car or whatever, and he just crashes. The way you're reading 3C undoes, it seems to me, registry service. Or I'm wrong. I could be, I mean, obviously I could be wrong.
Well, Your Honor, if you're right, then I had a good day.
Well, one of us has to agree with him, so.
That's true, and
that
that
doesn't always
sometimes,
happen.
that doesn't always happen.
Exactly. So if I may, and I'm sure my brother's going to go into this more, but because I don't want to argue against what you're saying, Judge.
Okay.
However, let me try to make it easy. We did get actual notice. In August of 2022, and I know it was already dismissed, but we were continuing with my motions for reconsideration because the judge had dismissed this. Now, one of the problems that happened, and it caused a lot of confusion, my brother, Attorney Gavignano, who was the attorney in the case, he filed, along with his initial, he served the registry. And then in August, he actually mailed certified mail to the last address we have, which everybody knew was not a good address, which was kind of useless, but he did it because it's a procedural step that's required. The problem is we didn't have an actual address, and before then, though, he submitted there was a 3D affidavit that comes from the Registry of Motor Vehicles, because they served Mr. Assed at the address they had, which was because he was cited at the accident. And so this 3D versus 3C business, I think, really confused matters for everybody.
Do we know how he responded to that citation, by the way? Or if he ever did?
I'm fairly certain there was never any response.
Okay.
In fact, Your Honor, the only response from Mr. Assed was when insurance counsel contacted him. He signed an affidavit with a case number saying he never lived at this address. Yet he didn't give his actual address. He said he lived somewhere in Rio de Janeiro, a city of, I think, 30 million people. Essentially, Judge, this should be good service. There should have been good service. And the reason, by the way, I talk about the original last and usual is the other argument that Odette didn't get to, that he should be stopped from even claiming he doesn't live in Medford because he made these misrepresentations that everybody relied on. Imagine if we had that information at the outset of this case. If we had an address in Brazil, in a neighborhood that apparently is known as a Tony neighborhood in Brazil, that we finally got somebody to hand this to his doorman who confirmed that he lived there and who assured the person that it would be delivered to him. You don't get much better service than that.
Can I ask you a question about the other defendant? It's my understanding from the docket that EAN Holdings LLC was dismissed with prejudice. Is that correct?
That's correct. The counsel for EAN Holdings cited a statute that this was sort of before I got into the case, or right as I was. He had cited I think it was a federal statute that protects them from a case like this. My brother agreed, and so therefore, they filed a stipulation of dismissal, releasing them from the case.
So they're out no matter what happens.
Rental car companies can't be sued for the tortious acts of drivers?
Again, Your Honor,
Well, it's not what this is about, so it's not
it was a
wasting time on it.
decision
but
that I didn't really get into.
That seems very odd to me, but all right.
It seemed odd to me, too. Ultimately, Your Honor, Your Honors, members of the court, we have two services that I would suggest are adequate. The problem was there was a disconnect when the judge in October of 2021, after consideration of motion to dismiss, after motion to dismiss for this inadequate service, she issued an order that said, now you have till November 30th to file your certificate of service, your certificate that you've complied with 3C. But again, 3C requires that certified mail to, and the way I've been reading it, Your Honor, and not to hurt my case, is or other proof of actual notice. I believe the case law does require some form of actual notice for service.
Well, but it also suggests that a return receipt is a reflection of actual notice, and it's not necessarily. It can be signed for by whoever's at the door.
True. And incidentally, on the return receipt in April of 2022, I sent registered mail to this gentleman in Brazil, and I didn't get a return receipt. You can't track mailings to Brazil on the internet. So ultimately, Your Honor, I think the problem here is timing. The problem here is that what we needed to do, we couldn't do in time for this judge, because she had already dismissed the case, and now we're in this posture of reconsideration. What I'd suggest is that that doesn't serve the interests of justice here. And Creed versus Audet is directly on point on this timing. The timing issue in 3C is forgiven, is extended, is loosened when there is an issue of a bad address, a misrepresentation, when that person has caused there to be the address problem. And with that, unless the members have questions, I would rest.
Thank you very much. Very interesting case, at least to me. Excellent argument. We will hear now. I find many of them interesting. But then I'm a judge. We will hear now from Attorney Lane.
Good morning, Your Honor. I may please the court. My name is Attorney Tom Lane. I represent ELIAS ASSED in this matter. Just as an aside, and I wanted to address your point, Judge Rubin, the Graves Amendment is a federal statute that bars claims against the rental car companies in the United States of America, as long as it's a situation that it's not a negligent entrustment case, that they've given the vehicle to an unauthorized operator. It's very clear law in Massachusetts. Every court I filed a motion 30 times.
But there is some kind of provision for if they recklessly rented the car to someone who shouldn't have.
That's their own negligence. If they're just being sued vicariously liable for the rental of the vehicle.
There was no allegation of that here.
None whatsoever. And because Mr. Assad was licensed in Brazil. He was licensed in Brazil, and I don't want to argue the facts, but I think the facts are important because Judge Buxton heard all the facts. Judge Buxton received the affidavits of the parties that were involved. Judge Buxton commented in one of her decisions that the plaintiff, the police report there he was not cited for not having a license. It doesn't list a license number on the police report. So clearly there was a license that was not, whether it was last and usual or an active licensed address at that point.
So can you discuss my question about how one complies with 3C and why it wasn't complied with here by mailing a copy of the process and a notice to the last known address of the defendant?
I don't think that was the last known address. My brother had already received an affidavit to that effect. Again, timing is important in this matter, and that's what was in front of Judge Buxton. A motion to dismiss was filed in March of 2021. The complaint was filed on the last day that the complaint could be filed within the 3 years. Service was then made on the last day when service was allegedly made by leaving it at the address in Medford. An affidavit was presented saying that that's not our address right there in March of 2021.
Wait a minute, I want to understand this, and you're not giving a date with everything, and I'm old. So the complaint, just say it all again, but with dates, please.
Sure. The complaint was filed, and I don't have the exact date, the complaint was filed in November of 2020. The accident happened in November, and I don't know if it was the 3rd or 4th, but the complaint was filed on the last day before the 3-year statute would run. The complaint was then served, and I say served, was sent, mailed to the, again,
the Medford address.
The Medford address, and that was on February 2nd. Once that complaint was sent, counsel for Mr. Assad, and there was separate counsel here, which I think is important for Judge Buxton was aware of that, because Enterprise answered the complaint. They immediately, and they were prepared to answer litigation.
They're out.
Well, but they were out a year later, so they were prepared to receive discovery.
We know who paid for Mr. Assad's counsel? Was it not the insurance company?
It was, well, again, because...
When you say separate counsel, but if they're both paid for by the insurance company.
They were both paid for. Enterprise is a self-insured entity that has a bond and a policy available here. They did pay for the counsel for both involved, and they're paying for me today also. So
well, I'm glad you're getting paid.
Thank you. I appreciate that. But so at that point, the motion
So the things that have happened are there was an accident in November 17. November 20, a complaint is filed.
Correct.
February 21, the complaint is sent to the Medford address. Now, at what point are you saying that the plaintiffs or plaintiff's counsel was on notice that the Medford address was bad?
In March of 2021.
Okay, so I'm not nunk-pro-tunking that piece of knowledge for the lawyer, right? So in February of 2021, why is the Medford address not the last address of the defendant known to the plaintiff?
It was not the last address. Well, as of February 2021, just because an address is listed on a police report does not mean that's not...
I agree with you, but the statute says shall be sent in the same manner to the last address of the defendant known to the plaintiff. It doesn't say the last actual address of the defendant. It doesn't say the last address of the defendant. It says the last address of the defendant known to the plaintiff. There's no punctuation in that phrase, so I'm going to read it as all one piece. So tell me if I'm wrong about this. I think that at the moment of service to the Medford address, the only information available to the only information the plaintiff had about where Mr. Assed lived was the Medford address. Is that wrong?
I think it is wrong, because I think there's a duty on behalf of the plaintiff to determine what the address was.
I'm sorry.
Let's just put that aside for the moment. Whether there was a duty, whether everybody dropped the ball in some various ways here, even if they were supposed to have looked at it, they didn't know. The last known address was the Medford apartment. True or false?
I don't concede that point. The last address listed on a police report. I'll concede that, because that's what was on the police report.
And other than the police report, what information did the plaintiff have about where Mr. Assed lived?
I don't know.
But you're saying they could have known.
They could have certainly known.
If they did some discovery.
They could have very easily...
Before serving, they're going to do discovery?
Excuse me?
Before serving their complaint, they're supposed to do discovery.
No,
because I've never heard of that order of doing
this. I did not say that, because they also filed a motion to extend the time to make service.
And then they should have done discovery
They could have...
on the non-served person who they didn't know where that person was.
They could have done discovery on Enterprise, which they did a year later, in April of 2022.
I've never heard of someone having to do discovery before serving process. Like, I've never heard of that before.
Well,
and it seems to me, tell me, when did they do registry service?
When? At which time period?
Yeah, I'm asking you, as part of your timeline.
Originally.
Their original service on the registry, when did that take place?
That took place in May of 2021, after they had received the motion to dismiss with affidavits from Mr. Assad and his son, stating that the Medford address was not the address and he was a resident of Rio de Janeiro. At the same time, the Counsel for Enterprise had already answered the complaint on behalf of Enterprise, and certainly, and Judge Buxton said this in one of her orders, the plaintiff could have sent, and eventually did in April of 2022, discovery to Enterprise where the complete rental agreements were all produced.
Do we have cases, do you have a case where a complaint was dismissed for failure to comply with 3C?
Yes, we cite several cases in our brief. In the Gifford versus Spear case, talks about how 3C is required, and talks about the notice requirement.
What's the citation?
358 Mass 658.
Okay. And I don't really understand. Your position is that there has to be actual service?
The statute requires. No, the statute requires actual notice. 3C says...
So explain to me why, if I read it that way, I haven't read the registry service rule right out of the statute. Someone comes into the United States from somewhere. They choose to drive here on the roads of Massachusetts in an unregistered vehicle. They smash into something and destroy property and injure someone. Later that night, they go to the airport and fly back to wherever they came from. They gave an address. I don't know what address it is, but they gave an address. It had something to do with this family. Maybe it's the kid's address, and it's in Medford. And they fly away. We have a statute that says you're not left without a remedy, Massachusetts resident who's been injured. You may serve the registry, and that'll count as service of process.
And you may also, that doesn't.
I agree. No, it counts as service, I think, because Rule 3C says it's about notice. You have to give notice of the service.
Okay, well,
but if you have to actually make sure it's received, then why do we have the registry thing? Then you could just serve the person.
What it requires is a reasonably and substantially immediate attempt to give the defendant notice.
Wait, where does that language come from?
That is Rule 3C, and that's the decision in Gifford versus Spare, the case I just cited to you. It's on page 18 of our brief.
Reasonable efforts. And you think everything that the plaintiff did was not reasonable efforts. He gets a police report, it has the address. In fact, the Commonwealth has sent a citation to this man at this address. That doesn't mean it's right, but on its face, it suggests that might be a good place to send it, right?
On its face, but again.
Yeah, but I don't have to believe the affidavit of the on the lam defendant.
He's not on the lam. He lives in Rio de Janeiro.
Okay, maybe he's not on the lam. He hasn't shown up in court yet.
Well, he's visiting his son who was in college at the time.
I don't know what he was doing here. Maybe he was working.
No, I don't think it's fair to be scurrilous.
Well, I don't think I have to accept an affidavit. How do I know if it's credible or not credible?
I think the Judge Buxton
can judge its credibility without seeing him testify?
Judge Buxton accepted it, and it's a de novo type hearing to determine service, and that's what was done in front of Judge
I would have
Buxton.
wanted him to be subpoenaed into court so the judge could see his demeanor as he explained.
Well, I think Judge Buxton allowed the motion to extend the time. She then issued an order in October of 2021 to very clearly follow Rule 9C. If you do this, didn't allow the motion to dismiss, gave 30 days to undertake those steps. And again, my brother, I understand he claims he didn't receive it. The dismissal entered at that point. Finally, in February again, the motion to dismiss reconsideration was back in front of Judge Buxton. She again, and that's her decision that was before the court, on February 3rd said he still did not comply with Rule 9C, did not make any effort to comply with Rule 9C, and suggested literally in court you should be sending discovery to the enterprise entity to determine that. That was sent, it was then done, and it appears that at some point in April or May of 2022, notice was then.
What's a plaintiff supposed to do if it's not a rental car and there's literally no way to find? I mean, what you've discovered is there's a police report that says, this gentleman says he lives in Brazil, but the person is gone. You can't sue them? You can't get an in absentia judgment against them for injuring you or destroying your car or whatever?
Well, you could potentially sue them, but I don't think it would be a collectible judgment because you didn't have.
You don't know where they are, but one day you might figure it out.
Well, you could do that, or you could also.
But I'm saying, you're saying it can't even go forward. You're saying if you don't know, dumb luck, Enterprise it was a rental car, right? And dumb luck, Enterprise in its computer system had this address. I don't think it even has the license number. I think it just has an address, but all right. And dumb luck, the guy still lives there, apparently, right? I mean, that's dumb luck, right?
Well,
but I'm trying to figure out what the rule is supposed to be. I thought we were protecting people in Massachusetts from out-of-state and out-of-country drivers who might leave the jurisdiction and not leave a forwarding address.
Well, I think it's protecting both sides because you're also protecting the person who could have a judgment.
Well, 3C says that to protect the defendant, 3C says that the judge will allow extensions of time so they can defend themselves.
Which took place in this matter. And an extension was allowed to make service basically from the first motion in March of 2021. It was never dismissed until December 14th of 2021.
When do you think the defendant had actual notice of the suit?
The defendant likely had actual notice because obviously he signed an affidavit. So I believe when counsel, I was not involved in the
That's in
trial
February or March of 21.
That's when the affidavit was signed.
He had actual notice as of then.
Well,
is that affidavit proof of actual notice?
And I don't know if I want to acknowledge it's actual notice. He had.
I know you don't want to acknowledge it, but.
Well, no, he had privileged and confidential communications with an attorney, and he signed an affidavit. But to say, again, I was not counsel involved.
Yeah, but do you think if someone's looking for proof of actual notice, because at some point he's allowed to file proof of actual notice, you think that affidavit might be proof of actual notice, or at least that a judge could find it was adequate proof?
I don't believe so, because I think under the laws of Massachusetts and the rules of civil procedure, you're allowed to file a limited appearance to contest.
You're allowed to file a limited appearance.
Well,
Right.
and it was a limited appearance only to contest service at that point, and you're allowed to combat that. Again, this is now well over 3 years after the accident.
Okay, but you're allowed to bring your complaint up to 3 years after the accident.
Correct. And then you have 90 days to make service. And this was now, 120 days at that point.
And was there an extension?
Extension was filed at the same day the court received the motion to dismiss. There was a motion to extend the time to make service, which the court allowed, which was not opposed at that point. Thank you.
Thank you very much. Great arguments, both of you. As I say, I find this incredibly interesting. I've never seen this circumstance before. But perhaps my colleagues have. I don't know.
Not yet.
Should we keep going? Either way, I'm fine. Keep going? All right. The next matter we will hear, did I say that case is submitted? That case is submitted. I guess I'm supposed to say that. The next case we will hear is number 22-1046. This is MB versus AG. And since I assume that reflects an impoundment order of some kind, we will not use actual names. And if there's anything else that's impounded, you'll let us know by not saying it. And we will hear first from, do I know who we will hear first from? I believe we'll hear first from Attorney Lewis. Is that right?
Yes, Your Honor.
Okay.
May it please the court, my name is Paul Lewis, and I represent the defendant, appellant AG. Here, to whom I will refer to as the defendant, here the defendant is asking this court to reverse the lower court's denial of the defendant's motion for relief from judgment, which would then have the effect of retroactively vacating the January of 2022 abuse prevention order extension that was sought and received by the plaintiff here.
Is there a 209A extension now in effect?
Yes, Your Honor. It's a good question. There's during the pendency of this matter, because the prior extension was only for a year, there was indeed a 209A extension evidentiary hearing, full evidentiary hearing, that occurred this past February. That is also on appeal before this court, notably docket number 2023 P0286. The issue in that is more straightforward. It's sufficiency of evidence, whether there's a reasonable fear of imminent physical harm under the
So one of the reasons I asked this question about information that's not actually properly before us is because we're always curious to know what the effect would be if we were to allow a petitioner before us, not in the 209A context, request. And am I right in thinking that it would be a little bit of a Pyrrhic victory for your client?
Your Honor, so the particular relief requested was a specific retroactive vacatur. It would be the defendant's position that if the panel agrees with the defendant's position here, then the abuse prevention order extension, insofar as it existed between January of 2022 and then this most recent evidentiary hearing in February of 2023, would be blacked out. Now, candidly, the reason that we invested the resources and took these steps was because out of this, I would submit, erroneously issued abuse prevention or extension stemming from the plaintiff's material misrepresentation, there were criminal charges that issued, and then there were potential criminal charges that went to a clerk magistrate's hearing. Now, it's also worth noting, to Your Honor's point, on completely different grounds, unrelated to this, in relatively recent months, I was able to have all of those dismissed because, for completely independent reasons, they were frivolous. However, at least one of those charges did in fact issue. Therefore, in addition to, I can't remember how Your Honor characterized it about the victory, I mean, there's a prerequisite for expungement here. It is the defendant's position that what happened here, where the plaintiff purported to meet an evidentiary burden without any evidence whatsoever by misrepresenting material facts in violation of Rule 303, both in open court and immediately beforehand, to the defendant's counsel, it's the defendant's position that's a complete injustice. Additionally, this was primarily briefed by the time that all of those charges were dismissed as being frivolous for independent reasons. This was primarily briefed. But nevertheless, of course, in the APO extension context, the case law is clear. This isn't moot. It's certainly not moot.
Right. No, nobody's saying it's moot. I just wondered what it was you were after here. So let me ask you a bit about the record. Am I right in understanding that the judge who heard the one-year extension that you're complaining of here is the same judge who issued the original brief order? In other words,
yes,
there's the ex parte order.
I'm prepared to answer the question, yes. So initially there was an ex parte order. That was Judge Stark.
Yes.
After a week or two, give or take, then there was the initial two-party hearing. That was a different judge. I want to say it was Judge Kunis. Subsequently, the year passes because it was under 209A1B, a one-year order. And then the January 2022 APO extension hearing at issue, but tangentially at issue here, was Judge Stark. 6 or 7, maybe 8 months later, the motion for relief from judgment hearing was Judge Fabry.
Okay, so I don't want to get to Judge Fabry yet. Judge Stark, round 2, why or was she entitled to include in her consideration of the showing before her the original affidavit that was filed by the wife when she came in for the ex parte order?
Is the defendant's
I'm not asking you whether that would be enough. I'm asking you whether Judge Stark was allowed to include that in the matters before her.
It's the defendant's position that she was not. The only hearing...
Why not? What's a case that says that?
The initial two-party hearing is the only review provided by law. That's the quote for APO extension materials, and that case is RS versus PB, 95 Mass Appeals Court, 372 at footnote 1. But significantly, even if she was permitted to consider that in the context of what I know my brother mentioned in his brief a number of times, the general totality of the circumstances, what was lacking here is a pure evidentiary foundation to meet the evidentiary burden of proof relating to facts that, quote, exist at the time the extension of the order is sought, that are a prerequisite to an APO extension order as a concept. In other words, without that, without either plaintiff testimony or alternatively submission of something to meet a given evidentiary burden for each successive APO extension request, absent maybe an intentional and express waiver, which didn't happen here, that's legal error to to issue an abuse prevention or extension, find that the evidentiary burden of preponderance of the evidence has been met without any evidence whatsoever.
But didn't you agree to proceed that way on just by proffers of counsel?
No. First.
Did you object?
No. And the reason for one thing, there was no express waiver of the right to have the adversary with the burden meet that burden with evidence. But the reason that it went this way is due to the material misrepresentation. That's what's so key here. That's the crux of this. That's why there was no waiver.
Okay, but this is a motion to reopen a judgment or vacate a judgment long after it's become final. You keep calling this a misrepresentation or newly discovered something. You have no affidavit from Attorney Conselman. Attorney Conselman was there, received this document, forwarded it to your client. What if Attorney Conselman, as a tactical move, didn't object to this because the plaintiff was sitting right there and didn't want to put her on the stand instead of this and have her weep openly or whatever might happen, and just thought, look, if we said pains and penalties of perjury under it, she's right here, she'll sign it, my guess is, or we'll have to put her on the stand, or they'll put her on the stand, and then this is going to go worse than I think. If it was a tactical decision not to object, how can the judge reopen?
Any decision relating to that would have undoubtedly been made under false pretenses. False pretenses that the
There are no
plaintiff
false
herself created.
pretenses. I looked at this for 1 second. It's obvious it's not an affidavit. It's just got a line at the bottom with a signature on it.
Your Honor,
So presumably, if Attorney Conselman is a competent attorney, and I don't see you arguing otherwise, although maybe your argument is otherwise, looking at it, Attorney Conselman would be, it says affidavit in the email, it's not one. So
Your Honor, I want to address, and this is a conflation, I think, that led to the erroneous decision by Judge Fabry. There are two different problems here. One, as you said, it's not an affidavit, but the more fundamental problem, and this is undisputed, wasn't disputed by plaintiff at the lower level, wasn't disputed by Judge Fabry in the decision, it's not disputed by plaintiff here, and it's clear from the docket, that was never submitted. One cannot meet an evidentiary burden.
Didn't go to the original judge. I mean, people make mistakes. There are mistakes on dockets. If I had an affidavit here from either Attorney Conselman or a ruling from the actual judge, this was not ever submitted, I'd feel more strongly that you demonstrated that it wasn't submitted. I don't understand why you didn't, I mean, except for maybe not wanting the answer, why you didn't get something from Attorney Conselman. It seems to me that the question of what actually went on here is really important.
Your Honor, I'd submit that there are no disputed facts here. The docket necessarily controls. The plaintiff was aware of this issue and had a year, and in fact, moved to correct the record on another unrelated point, didn't move to correct the record here.
But you didn't appeal.
Sorry?
You didn't appeal. There's no direct appeal. So you're trying to reopen, and the question is abuse of discretion on reopening. I'm not saying you might not have won on appeal if you had raised it. I mean, you say it's newly discovered, not to Conselman.
It is newly discovered as to Conselman.
No, it's newly discovered as to you. Conselman had it in Conselman's hand at the...
Your Honor, that is an irrelevant point when it was never submitted to the court. Conselman had no way of knowing it was never submitted to the court because Attorney Fung, this is the key, this is the misrepresentation, said in open court that he had submitted a, quote, affidavit containing further details about the basis for the APO extension request that generally speaks for itself. He didn't submit anything. This isn't disputed. The fact that it wasn't an affidavit is separate, and that was Judge Fabry's error. He screwed up, Attorney Fung screwed up in two ways.
Well, you say it wasn't submitted.
Correct. Attorney Conselman had no way of knowing that it wasn't submitted.
The attorney says it was submitted in open court. The judge doesn't say, okay, where is it? And the other side, not having seen that it's submitted, doesn't say, Your Honor, so far as I'm aware, this hasn't been submitted. wouldn't it have to be done in open court anyway? I mean, I don't know actually how these things, right, they all seem so informal, and I'm not in favor of that, but they do seem wildly informal, some of them.
Your Honor, under Professional Conduct Rule 303 and the comments to it, when an attorney says he did something, everyone presumes that's true. And additionally, when the attorney did in fact email something to Attorney Konzelman immediately beforehand, Attorney Konzelman had no way of knowing that that was not on the docket, that that was not actually before her. Judge Stark screwed up. She did the error. She did not actually review any evidence. She couldn't have reviewed any evidence.
Well, that's not true, because I'm looking at page 32 of the record appendix, which is the hearing on the extension hearing, and Judge Stark says, I'm trying to figure out what the history is regarding abuse. And I understand that Mr. Fung is trying to explain to the court why it should be extended, but I'm looking at a police report, and I'm looking at the history between the parties. How do we know that the judge didn't have a copy of the papers in front of her? How do we know that Attorney Fung didn't walk up to the clerk right before the hearing started and say, may I pass you the submission for the judge to have during the hearing?
Because it wasn't in the court's record, and it's not reflected on the docket, and Attorney Fung didn't argue to the contrary at the lower court.
The police report was in the record.
The police report, that's correct. The police report, which doesn't allege any abuse.
No, I understand. I'm just
submitted a year ago. Right. I just want to make sure that the two salient issues here are parsed out. The first is whether, in a given successive 209A, Section 1B, abuse prevention order extension request, whether to meet an evidentiary burden, some sort of evidence has to be submitted, whether it's testimony or affidavit. That's the first question.
Right, but there is also a case, your brother cites, that allows this proffer by, if it's not objected to, this proffer by attorneys. And in the proffer, the attorney says the salient portions of the not affidavit, but of the signed statement. The attorney repeats them. I understand they weren't sworn, but there was no objection.
There was no objection to the fact that it wasn't submitted because of the material misrepresentation. There didn't have to be an objection because this flows through 60B. That's the key here. 60B gives you up to a year to discover a material misrepresentation, and the record's clear. No such documents submitted to substantiate an evidentiary burden in 2022.
Okay, so the misrepresentation, maybe I misunderstood. I thought the misrepresentation was that it was an affidavit.
No.
You're saying the misrepresentation is that it was submitted.
Yes, this is what I'm trying to say. This is why Judge Fabry was confused. The misrepresentation was that it was submitted at all. That's the material misrepresentation, and it's not contested. It's reflected in the docket. It was never submitted. That's why through 60B, there didn't have to be any sort of preservation of this particular issue because within a year, a material misrepresentation, mistake, misconduct, whatever you want to call it, was discovered.
Have been a tactical decision not to object to it not being submitted?
Attorney Konzelman had no way of knowing that it wasn't submitted because it was served to her and it was told that it was submitted and
how do you submit something into evidence without the opposing side knowing it? Where do you do that? How would you do it?
Presumably an email or some sort of electronic submission.
Is that a way that you can submit something to this court 30 minutes before a hearing?
I'm sorry, I didn't hear the question, Your Honor.
So it was emailed 30 minutes before the hearing?
To counsel.
To counsel.
Counsel, right. The clerk was not CC'd on that. It is not contested that this thing was not submitted. This court in the Hathaway case made this, it's unpublished case, but it made this particular distinction that although there was no timely objection, the aggrieved party did not waive its right to subsequently raise the relevant issue because the motion was treated as one for relief under 60B. And significantly, Judge Fabry didn't find that Attorney Konzelman had any way of knowing. And in fact, the plaintiff conceded that very point as to Judge Fabry's decision itself on page 47 of the plaintiff's brief. They had no way of knowing this wasn't submitted. This is therefore not waived because it flowed through 60B, and it flowed through 60B as a result of Attorney Fung's statements to the same effect, first to Attorney Konzelman by email, and then in open court.
Let me ask you this, although maybe your answer is the docket. Let's say, in fact, everyone was looking at that document. Attorney Consulman saw the judge with a copy of it, or maybe was handed a paper copy of it, and saw the judge handed a paper copy of it. It doesn't say anything in the record about it. Do you have a burden to show that didn't happen, or if the docket doesn't reflect it, we have to treat it as conclusive?
The docket and the court's file control here. Under Rule 77C, when the clerk receives something, that's the clerk's duty to put it in. There's multiple record appendix pages, the docket, my affidavit, and I think 2 of my affidavits. It was not in the court's file, and significantly, Attorney Fung didn't argue that. Significantly, the plaintiff did not move to correct the record in this respect, even as I was raising this up. In that respect, it would be the plaintiff's burden. When something's not in the record and the plaintiff feels it's not in the record as an error, especially when they're fully on notice of the issue, because I'm moving through 60B, moving it up here, they have the burden to correct that record. Nothing of the sort happened.
They do here. I agree with that.
I'm sorry?
They do here, so that if the record doesn't include the document, but they know that it was submitted, I suppose they are supposed to correct the record. Go to the original judge and say, could you put, can we get a finding from you that it was submitted, or can we get a correction of the docket or whatever?
That's right, and significantly, the plaintiff did. They fully knew how to correct the record, was paying attention to this case, and did, in fact, do that on a completely unrelated point relating to the transcript. It's significant that
your
they did
time
here.
has long
Thank
expired.
You. Well, I appreciate Your Honor's extra questions. I'm always
Thank you
eager
very
to
much.
answer them. Thank you.
We will hear now, I'm doing a bad timekeeping job. We will hear next from Attorney Madison.
Good morning, and may it please the Court. Nick Madison for the plaintiff, MB. I'd like to begin by responding to a factual point made by opposing counsel, which is that it was uncontested that this document, the signed statement, wasn't submitted to the court. And this is an important point. And in fact, it's the linchpin of that portion of their argument is that this in fact wasn't submitted. The issue is that wasn't argued before Judge Fabry on the motion to vacate. Both parties in the transcript took the position that it referred to the document as being submitted. And this is on page 98 of the record appendix, which is the transcript of the hearing before Judge Fabry on the motion to vacate. Attorney Fung says, my client is willing essentially to affirm the truth and veracity of the document that I submitted in January of this year. Coming into court saying, the document was before the court. I did submit it. And so it was contested below. There's also cases, Attorney Lewis, who was the attorney at that hearing, refers to the document as being submitted. The submitted appears frequently in this transcript in reference to that document. It wasn't argued below, and other than being referred to as being submitted. And actually, when you look at Judge Fabry's decision on page 2 of it, he writes, the contention that the quote-unquote affidavit submitted at the January 2022 hearing was not sworn under the pains and penalties of perjury. He implicitly found that it had been submitted. So it wasn't argued before Judge Fabry on the motion to vacate. He found, in fact, that Justice Rubin expressed some confusion at the argument. I have to admit that I was confused too, because after the opening brief of the party, I assumed that he was referring to the argument that the signed statement wasn't an affidavit. In his reply brief, he shifted that a little bit and said, yes, it wasn't an affidavit, it also wasn't submitted. That wasn't presented below. Judge Fabry implicitly found that it had been submitted, and for a factual finding that's the linchpin of their argument, the defendant as the movement.
How can the judge find it was submitted? The judge wasn't there, and it's not on the docket, and it's not in the case file. I mean, what's that finding based on?
On the contentions of the parties at the hearing, and I would also reference in the defendant's motion, the motion to vacate, excuse me, because I want to refer to it correctly. The motion says, as such, this court erred when it treated this document as an affidavit for evidentiary purposes.
What page are you on?
That's on, so this is page 12 of the defendant's motion, which I realized was not included in the record appendix. But I would submit to the court the motion with the transcript. It's clear that
assuming the two of you can agree that there's a true and correct copy of it somewhere, could you submit that to us, please?
I would be happy to, or my brother, we can conference on it, and one of us will get it in front of you. So everyone below had taken the position that it had been, in fact, submitted. The judge implicitly relied on the contentions of the parties in finding that it had been submitted, and that leads into the waiver failure to object argument rephrasing, a motion to vacate, or like a 60B motion, is not a substitute for an appeal. If they had the facts before them, then they had to appeal, to object to the time and appeal. My brother makes the argument that, well, they didn't know that this had been submitted, putting aside the factual issue that we've just addressed. The Judge Fabry, also found that the contents of that document was essentially identical to the initial ex parte affidavit, which was before the court. The court had to consider the prior.
It's not the same.
It's not the same.
It lacks, the original one lacks any evidence of the critical question. Is she still in reasonable fear of imminent bodily injury? So you need evidence since the first thing, and it need not be a violation, of course, of the first order, but there has to be some evidence of that. Now, maybe there doesn't because you're allowed to do this proffer thing, or maybe it doesn't matter if there was no objection, or maybe, but in general, the rule is there has to be evidence of it, and that appears in two places, the signed statement and the oral representation of the attorney.
Yes.
So I don't understand how the old thing is good enough for an extension 2 years later.
You're correct, Your Honor. The point I would add to that, which is a factual point, and Judge Fabry so found, was that Attorney Conzelman, who was representing the defendant, specifically informed the court that she wasn't objecting to an extension, she was only objecting to the length. I think that is the length of the proposed extension. I think it's fair to say that that affects.
Well, I don't really read it that way. I think it looks a lot more to me like Conzelman recognized that it was going to be extended, objected, though, for the record, but recognized that it was going to be extended, presumably because the allegations in the signed statement are serious.
Yes, Your Honor. What I would point to is there was some ambiguity involving what she was objecting to. And how,
I agree with that. I mean, she wasn't pressing it hard, but I think fairly read, you got to count that as an objection. I do. You don't have to because you're the litigant.
I would just point the court to this line, which is on page 32, which is from the extension hearing. And so this is Judge Stark asking for clarification. So your client is not objecting to an extension, but he's objecting to a permanent order and a very long order. Is that what you're saying, Attorney Conzelman? Yes, yes.
But then she goes on to say, I mean, obviously, he would like the restraining order to be dismissed, and we dispute the abuse allegations, but I'm particularly objecting to a long length.
Yes, Your Honor, and I think that to get into Justice Rubin's point before, there may have been very tactical reasons for trying to have it both ways. Your Honor's...
Not have it both ways, but preserve your rights, but not bother a judge who's not going your way with a whole Megillah about it. I mean, that, and in fact, it wasn't made permanent, and it maybe could have been, and that might be a big win for a Conzelman.
Certainly, Your Honor, but I would suggest that it was a tactical consideration to phrase it in a specific way, and Judge Fabry, reviewing this, so found that that Attorney Conzelman found that she, explicitly stated to the court that she wasn't objecting to an extension, but to the order. And I don't think there's anything inconsistent with his findings with Judge Fabry's findings as suggested by my brother, with parsing the somewhat ambiguous objections, including this clarifying question in that way. I would just like to refer back to, because the defendant is making kind of taking a scattershot approach to this motion of, they also make some due process arguments that there was no evidence to support the extension, or that the judge must have relied on some impermissible factor like a previous extension, or the fact that the judge didn't testify, because there was no kind of derivative of the no evidence argument. As suggested in questioning before, Judge Fabbri found no objection to proceeding by proffer. The evidence included in the proffer was properly before the court, and the prior, ex parte affidavit was also before the court, which, as suggested, provided quite significant evidence of substantial physical sexual abuse, mental health issues on the part of the defendant, and substance use issues on the part of the defendant that, as Judge Fabbri found, would have, from I suppose, a sufficiency lens, would have justified the extension of the order. And so those due process issues fall away once you actually look at what was before the court, and the Vitone or Vitoni case, apologies for the mispronunciation, that permits 209A hearings to go forward on the representations of counsel. Seeing no further arguments, I would rest on my brief.
Thank you very much.
Thank
Excellent
you.
arguments by both of you. Another interesting case.
It's submitted.
And it's submitted. Our final matter of today's sitting is number 23-333. This is a partially impounded case, so I urge counsel to remain aware of that and not use names or any other impounded material. It is KM versus J.P.M. And I believe we will hear first, when everyone is ready though, from Attorney Salwin.
I might just have a moment, Your Honor.
Sure, sure.
Good morning, Your Honors, and may it please the Court. My name is Attorney Chris Sawin, and I'm here representing the appellant, who is also the defendant in this matter and father in the case, regarding whether or not the trial court improperly concluded that the defendant had committed abuse under Chapter 209A, Section 1, and whether or not the court had improperly extended that 209A abuse prevention order last year on October 5th of 2022. On behalf of my client, I would ask that the court vacate the October 5th, 2022 restraining order and enter an order to destroy all the records of the vacated order because the plaintiff and wife of the matter had failed to meet her burden of proof as to whether or not she was in fear of imminent serious physical harm. This court has repeatedly warned that a judge must consider carefully whether serious physical harm is imminent and should not issue a 209A order simply because it seems to be a good idea or because it will not cause the defendant any real inconvenience.
So would you agree with me that we are reviewing the issuance of this extension order for abuse of discretion?
Yes, Your Honor.
And also that we defer to the credibility determinations of the trial judge when we do that?
I believe that is one of the factors that the court can consider, Your Honor, yes.
What is your best case for why we should conclude that the wife's allegations, if they have been accepted as true by the court below, are inadequate to show an objectively reasonable fear of imminent physical harm?
I would suggest to the court that Smith v. Joyce, 421 Mass. 520, 1995, circles back to my point is that I believe, and my client believes as well, that given the condition of the divorce litigation at the time the two-party hearing was heard, in connection with, at the time, the wife was about 5 or 6 months pregnant. My client believes that the judge simply issued the 209A order as a bridge until the probate court could process the divorce paperwork. Because
I completely take you at your word, and I suspect that your client does believe that, but the question that we need to answer is, looking at the record as accepted by the trial judge, did that judge commit an abuse of discretion in extending the order? So how does Smith address that? In what way is Smith helpful for you on that point?
I guess in that particular context, Smith is more helpful with the fact that the argument of whether the judge issued it simply because the judge thought it was a good idea at the time to bridge the gap until the divorce litigation could begin. But more on point with what Your Honor is asking me, I believe maybe the Keene matter, 60 Appellate Court 667 from 2004, specifically was about, in that case, a defendant known for having a temper and owning firearms. I'm not suggesting that my client has a temper. I'm actually arguing the contrary. But for a case at law, the Keene matter, that particular defendant was known for having a temper, owned firearms, even made jokes about, quote, taking care of someone, but yet that particular judge found that that did not constitute abuse. And then reflecting back on the matter before Your Honors, my client is a lawful firearms owner. He was honorably discharged from the United States Marine Corps. He admitted on his direct examination that he suffers from PTSD. More so that suffers around a little bit of depression, having some anxiety around crowds, things of that nature. Nothing was ever violent. In fact, on cross-examination of the wife, I specifically asked the wife whether or not my client had ever physically harmed her. The answer was no. Whether my client had ever verbally threatened her, the answer was no. It really resulted from what I would suggest from the Dunkin' Donuts parking lot incident, and I use that term somewhat loosely because I wouldn't even suggest it was an incident, but rather I would suggest that is what the wife is clinging to, that is with respect to her being in imminent fear of my client.
Wasn't really the conversation after the fact, I'm coming back to the house after having been out of the house for a long time, wasn't that really kind of the linchpin?
I would suggest to the court that my client had a number of personal belongings at the house.
But that's not what that conversation was about, right? That conversation was about coming back to the house, not like coming back for a minute to pick up my box. Correct. I don't believe there was any further context about why he was coming back to the house. I just know what my client and I spoke about, and I don't believe that's accurately reflected in the record. I would suggest that it wasn't a threat to come back to the house to cause any sort of harm, because my client's never threatened the wife before in the past. No, I agree that I'm not sure, because I don't know what to make of the tossing of the bag. I don't know what to make of because I don't know everything about the backstory, getting out of the car to confront the wife. Increasing acts of violence against inanimate objects, to be sure, but including this destroying of a vacuum cleaner, which obviously isn't a person, but it's, you know what I mean? People get angrier and angrier.
Right. Expensive vacuum cleaner, Judge, yes.
And, it seems tough. We leave judgments of, credibility to say as a matter of law, all right, assuming the judge believed there was subjective fear, which I don't know how we don't have information, we can't change that finding unless it's clearly erroneous. The only question for us is it reasonable?
I'm happy that Your Honor brought that up, because I don't know if a reasonable person would be afraid of their spouse breaking a vacuum cleaner. I don't know if a reasonable person...
In this context, these people split up while this woman was pregnant with his child. I don't know what people... You know what I mean? I have no idea how angry... I've seen people become awfully angry about breakups. I've seen people do actually terrible things because of breakups. That doesn't mean your client was going to. It's very difficult, though. The judge found it was reasonable, and you're saying as a matter of law it can't be reasonable. I don't know how to, I mean, obviously we can look at other cases and just see what wasn't reasonable, I guess.
I would, and to be clear, the vacuum cleaner and the throwing of his dip spit bottle was before the marriage broke down, before the divorce, before my client moved out of the house, all of that. And I would suggest at the time that they were, happily married, and I don't know if a reasonable person would be afraid of that. I mean, the wife on cross-examination acknowledged that she was well aware of my client's military background, well aware that he was a lawful gun owner. In fact, the wife admitted she was a lawful gun owner as well. She was well aware of his PTSD status, that she wasn't afraid of him. Would a reasonable person acknowledging all those things truly be afraid of their spouse who broke a vacuum cleaner in the garage? I don't know, Your Honor. I don't think so. Would a reasonable person be afraid of their spouse throwing a dip spit bottle at a can, missing the can, and hitting the ground? The wife acknowledged it wasn't thrown at her, that she wasn't afraid of it.
It shattered.
Correct, shattered. But the wife did acknowledge it wasn't thrown at her, that she wasn't harmed by it, that she wasn't threatened or felt unsafe by it, but then later uses it in an affidavit before the court as further support that she isn't afraid of him.
But that's
yeah, go ahead. The procedural posture that we are in as an appellate court is all of the things you're saying the wife admitted, she admitted in front of the trial judge. And then the trial judge reached a conclusion and entered the order. And so, again, as Justice Rubin keeps asking, can we say as a matter of law that the judge abused her? I think it was a female judge, I can't remember.
Male judge, Judge Byrne.
Sorry, I always default to the women. Abused his discretion in making those credibility determinations. And the thing that guides us when we're trying to figure that out is looking at other cases and seeing, well, in a similar set of circumstances, was this outside the bounds of a judge's considerable discretion? And obviously, it could be that any one of us sitting up there would have reached a different conclusion, but we weren't there. So that's why we keep pressing you about the cases and the standard of review, because that's what guides our review.
I think one of the more important issues was that towards the end of the hearing, I believe there was some conversation with the trial court about the status of the divorce proceedings, and I had, I'm paraphrasing, said something to the effect of a divorce complaint has been filed, it hasn't been processed by the court, therefore we can't go to the probate court at this time for further relief.
But wasn't that all in the context of how to deal with the issue with the child?
Correct.
I take it you're indicating that the primary motivator was just like, as you mentioned, a bridge.
Yes, Your Honor.
Right? But I viewed that discussion not like you'll be in court soon, so I'll give you this order, but it's what do we do with this child situation? And the couple had been dealing with it on their own. Didn't need to be dealt with in the order.
Sure, and I would respectfully suggest to the court that a way to deal with child custody is not automatically through some sort of abuse prevention order. I don't think that an abuse prevention order should be used as a vehicle to determine custody. I don't think that's the standard under the statute, which is why I think that under the Smith v. Joyce matter, when the court asked my sister how long of an order, my sister responded, 6 months, Your Honor, that should be sufficient. And I think that if someone was truly in fear of someone else, they would want to go for the maximum, get a year of an order going, and that wasn't the case. And that's why I'm leaning on the fact that this was in fact used as a bridge to get these folks from where they were until we can get in front of the probate court. I would suggest that a reasonable person who's actually in fear of someone else would want the maximum duration of some sort of abuse prevention order to truly protect that person from harm.
Isn't it an equally plausible explanation of the request for 6 months to say, as you have said to us today, this was a pre-existing relationship in which the wife had never been in fear of the husband before. There is suddenly an uptick in behavior that is worrisome to her, including the parking lot incident, and that she was hopeful that 6 months would be long enough for that sort of uptick to settle down and for them to go back to being able to be cordial and non-threatening to each other.
It's possible, Your Honor.
And the reason I ask that is not because that's what I think. I don't think anything, but because if we're looking at abuse of discretion, we need to be very careful about reading motivations into requests that are made to a court.
That certainly is a possibility, Your Honor. I would further suggest that, the testimony that were given by both parties suggests that the wife was not harmed at all by the exchanging of these two bags that occurred at the parking lot. It was a public place.
But harm is not required under the statute, right?
No, Your Honor. But I think that the fact that the wife is leaning on the fact that she was fearful of the husband because of the manner in which he handed her the bags, I would suggest that a reasonable person wouldn't really be fearful of something like that, even if...
Well, she says he'd never done anything like that before.
Correct.
And that he threw the bag at her. I understand there's a factual dispute there, but that's her position.
Even
and that
tossed,
it hit her. And that he was using bad language, not in the casual way in which any of us might on a daily basis use bad language, but actually directed at her. And that he was doing it in front of a child who was, granted, not old enough to use the language on its own, but certainly of an age where language acquisition is going on, and that presumably shows less than clear judgment about how to be behaving around your child. So I don't think it's only that he handed her the bags in a less than respectful manner, but the full suite of circumstances that the judge was looking at.
That's certainly a possibility, Your Honor. I would further suggest that, insulting words is simply not enough and doesn't rise to the level of abuse under the statute. I understand that looking in the totality of the circumstances, a court could have determined otherwise, but I think looking at the manner in which the bags were given to the wife, I understand that Your Honor mentioned there's a factual dispute about that, but even if my client did toss the bags at her feet and when he handed the bag to her, it happened to maybe hit her in some way. She never sought medical attention, and he was using some profanity. He acknowledged that he uses profanity in his everyday language. A lot of military veterans do. The wife acknowledged on cross that yes, that's true throughout the history of their marriage, and I would suggest that being a historical piece of their marriage of using profanity, and that even if the bags were thrown in some way at her, that it doesn't necessarily rise to the level that he's going to imminently physically harm her. And I just don't think that a reasonable person would think that otherwise as well. And with that, I understand my time is low, and I rest on my briefs unless the court has any further questions.
Seeing none, thank you very much for an excellent argument.
Thank you.
We will hear now from Attorney Klimas.
Good afternoon, Your Honors. Anna Klimas on behalf of the appellee. Your Honor, I would suggest that this is a very straightforward, very simple case, cut right to the chase, that there was absolutely no abuse of discretion. The judge in this case in the trial court heard testimony from both parties. Exhibits were submitted, which included a police report, which included a written opposition filed by the defendant, which had affidavits of support. In addition, both parties testified, both parties were subject to cross-examination. The judge sat in the best place possible to determine the credibility of both of these witnesses. I understand that there's a dispute as to the facts, but you can look to the trial judge who determined that my client's subjected fear was objectively reasonable. And in this case, there are several facts and circumstances from which the trial court judge could have relied upon. We've already discussed several of them, but I think it's important to note that there was a discussion surrounding the incident that occurred at the Dunkin' Donuts parking lot. That incident was in conjunction, should be reviewed in conjunction with all of the other acts that had kind of culminated into this act. Once the incident occurred in the Dunkin' Donuts parking lot, the record supports that she was threatened, that she was scared, and that she was seriously alarmed by that behavior. This isn't just some whim or some kind of inconvenience or a good idea issued by the court. She testified to the fact that she was threatened and scared and seriously alarmed by this behavior, so much so that she contacted the police. So much so that that evening she had her father and other family members come to the home so she wouldn't be alone with her young son. And she deadbolted the doors so that he could not enter the home after saying, yes, I'm going to return to the home. And while that I'm going to return the home did not have an actual threat, his erratic and unstable behavior, coupled with that, and his escalating and emotional argument created that reasonable apprehension that force might be.
Your brother says that these incidents with the vacuum cleaner and the somewhat disgusting spit bottle that everyone talks about took place before they split up.
No, Your Honor. So the parties had been discussing a dissolution of their marriage for some time. Husband actually filed the complaint for divorce in I believe it was in August he had filed, and this incident in the Dunkin' Donuts parking lot took place towards the end of September. These incidents were right before.
When was the vacuum and was he still in the home then?
I believe he was in the home, yes, prior to vacating
And had
home.
anyone filed for divorce?
Pardon?
Had anyone filed for divorce at the time of that?
He filed on September 14th, I apologize, I don't have the specific timeline as to when they happened, only that it happened in a short time period prior to the Dunkin' Donuts incident.
How much, if at all, can we take into account the ownership of firearms?
I think it is part of the totality of circumstances that elevated her fear, if you will, because according to the record, she had he was being increasingly argumentative. This was a behavior she'd never seen before. This was, he would come by the home unannounced, creating this fear in her, and that he would be confrontational, cryptic, and paranoid. These are all words that she used when testifying about his behavior. Having a firearm, having the PTSD diagnosis, having this behavior that she's never seen in the history of their marriage increased her fear and caused her reasonable fear of imminent serious physical harm, which I believe was present here. The judge heard credibility based on the testimony of both parties, and also I think is strongly supported by the fact that this isn't just her giving lip service, if you will. She actually called the police. She was so afraid, and she told him she was calling the police because she was so afraid of his behavior that had escalated to that point on that September 25th day. I think.
No, go ahead.
Oh, I apologize. I thought you were going to say something. And additionally, the defendant cites to the fact that there has never been a history of abuse between the parties. He's never put his hands on her before. And I would cite the court to Constance C. versus Raymond R. There doesn't have to be a history. And I think the judge who heard the testimony evaluated it in these circumstances, and I would ask this court not to overturn the issuance of the order.
I see no further questions. Thank you both for very helpful arguments. The case is submitted. This brings us to the end of today's sitting. I'd like to thank the court staff and particularly the court officer for all of their assistance today. And we stand in recess.